Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Thank you for your time. Goodbye. Hello and welcome to a special interview for The Wire. Was the Supreme Court right in upholding the amendments to the Prevention of Money Laundering Act? Or has it erred and made a mistake for which the Indian people could pay a high price? That's the key issue I shall discuss today with one of the most illustrious former judges of the Supreme Court, Justice Madan Lokur. Justice Lokur, let me start with the Money Laundering Act. Before I end, I'll come to the Enforcement Directorate as well. Was the Supreme Court right to uphold the amendments to the Money Laundering Act, which the Hindu says allow for virtually unbridled powers of summons, arrest, and raids and make bail nearly impossible? Or has the Supreme Court erred and made a most unfortunate mistake?
Yes, thank you, Karan. You see, it's like this. There were several sections of the Money Laundering Act that were under challenge, right? So to say in a blanket manner that every amendment should have been struck down may not necessarily be correct. You see, for example, you have the definition of money laundering, for example, right? There's written a long judgment on the definition of money laundering and why it is necessary and so on and so forth. Then there's something about investigation, there's something about bail, there's something about arrest. So on a blanket basis, to say that everything that they have done is wrong may not necessarily be correct. Some of it may be correct. I don't know. One has to analyze the judgment very carefully to see every aspect, whether it is correct or it is not correct to that extent. But there are certain provisions, which I'm not particularly happy about, but which have been upheld in the past. For example, the provision for bail. Right, that has been upheld, and they have relied upon judgments, delivered in the past, including, I was very surprised, including under the Companies Act. So some of these things need to be reconsidered, certainly.
I'll come to the details in a moment's time, but let me first give you the Supreme Court's justification for upholding the amendments. The court says, first of all, that the Money Laundering Act is sui generis. Secondly, it says that money laundering is an offense against the sovereignty and integrity of the country. And thirdly, it says money laundering is no less heinous an offense than terrorism. Do these three reasons justify the pretty draconian powers the Money Laundering Act confers on the government?
No, I don't think so. They have referred to some international conventions, the Vienna Convention and the Palermo Convention, to say that money laundering can impact, the sovereignty and integrity of a country. That seems to be the, internationally accepted view. But the internationally accepted view is about, not an individual doing money laundering, but a group that is doing money laundering, a syndicate kind of arrangement. There it can be a problem, but here in our statute, to expect one person, an individual who is doing money laundering, that individual can, his money laundering can impact adversely impact the sovereignty and integrity of the country is very, very difficult to swallow. That is one. About the law being sui generis, I think every law is sui generis in that sense. I mean, the penal code is sui generis, the civil procedure code is sui generis, so that can hardly be a justification. The Supreme Court has also said, that we have to look at the perception that Parliament has. Right now, if you look at the perception of Parliament, and the Supreme Court says, we can't go behind the parliamentary perception. Now that's a little vague. Supposing Parliament perceives something which does not exist or which cannot exist, are you going to say that, because Parliament has said, it exists or is likely to exist, therefore, we hold a particular point of view? I think that might be stretching things a little too far in the sense of being, uncanalized, perceptions.
So, in a nutshell, you don't believe these three reasons actually justify the draconian powers of the Act. You have differences on practically all three of them.
Yes, in a sense, because like I said, if you're dealing with an individual, if you're dealing with a syndicate kind of thing, right, then perhaps the sovereignty and integrity part may apply, but it would not apply in the case of an individual. It's very, 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 very unlikely for for it to be applicable so far as an individual is concerned. But if it's a syndicate, organized group, maybe yes, it can have an impact. Drug cartel, for example, it can.
Let's then, at this point, Justice Lokur, come to some of the details that have worried people. Because a person doesn't have access to the enforcement case report, he or she doesn't really know why he or she is being investigated or whether he or she is being summoned as a witness or an accused. Quite often, even the full grounds of arrest are not shared with him or her. Doesn't this unfairly load the dice against the individual and fairly heavily in favor of the government?
It does. It does, certainly. Yes, it does. And you have to look at it in a particular context, right? The Supreme Court says two things, as I have understood it. One is they say it's an internal document, right? So why should somebody have full knowledge of it? But in a criminal case, so is an FIR. It's an internal document. I mean, it has been made public by law, but it's an internal document. So you can very well say that why should an FIR be given to anybody? Okay, that's one reason that the Supreme Court has said that we need not share the ECIR. The second reason the Supreme Court says it can, make investigation difficult, right? Because the guy knows what's happening. But so also in an FIR, if you tell the person an FIR, he will know what's happening, and he can make the investigation difficult. So what do you do? I mean, it's okay to say that the words are different. FIR is different from ECIR. Why? Because the alphabets are different. But the sum and substance of it, is more or less the same. Okay, so that you have to look at it in a larger picture. Unfortunately, I think, in my view, I think the Supreme Court has looked at some of these issues in a narrow manner. But you're dealing with a legislation having a larger, context and a larger application. So you can't segregate. This section is okay, that section is okay, this word is okay, that word is okay. There's a difference between inquiry. There's a difference between inquiry and investigation. You can't, do this micro, investigation kind of thing.
Clearly, Justice Lokur, you have differences with the Supreme Court on this particular issue. Let's come to a second. After deciding that the Enforcement Directorate are not police officers, the Supreme Court has permitted any statement that an individual gives as part of an inquiry to be used as evidence against him or her. Isn't that, in effect, permitting and legitimizing self-incrimination?
Yes. Now, here again, the Supreme Court has considered earlier judgments, right, under the Customs Act and Excise Act and so on, and said that these people are not police officers. Okay, the Supreme Court has held that they're not police officers. But again, look at it in the context, that we are dealing with. I'm not saying that the judgments relating to customs officers and police, excise officers and all that is correct, or that the judgment under the Narcotics Act and all that is correct. I'm not going into that. I'm again looking into the wider context. What is a police officer, right? A police officer is someone who can coerce you, right? Put you under duress. Listen, I can arrest you if you do a certain thing. Okay, law and order is one aspect, but I can arrest you. I can take you into custody. All right, and I can investigate whatever you're doing. So that police power, is what is important. So now these officers in the enforcement directorate, or officers in the customs or excise and all that, exercise that kind of police power. You can go, you can search somebody's house. All right, you can say that, listen, you sit in that corner while I search your house. The person can arrest you, right? File a case against you. Again, the Supreme Court says there's a difference between a charge sheet and a complaint. All right, different words, but the effect is the same. Then you arrest a person. So look at it in that larger context. Now, if you look at it in that larger context, officers of the enforcement directorate would fall within the definition, as would, I would say, customs officers and excise officers and other officers of that nature who exercise powers of that nature, as police officers. And if they are police officers, the law in India has been always that a statement made before a police officer cannot be used against that person, right? Because it is being done under some kind of a duress or some kind of coercion. Coercion may be not the correct word, but under duress. So to that extent, to say that the statements that are recorded by the enforcement directorate can be used against the person accused of an offense would not be correct, because I think that the person would fall in the category of a police officer.
Once again, Justice Lokur, you differ fairly sharply and significantly with the Supreme Court. Let's come to a third item. The conditions for bail under PMLA are extremely onerous, and you virtually have to prove your innocence to qualify. Should bail for a person who is technically innocent be so difficult to obtain, even if he or she is accused of money laundering?
Yeah, you see, again, what has happened, unfortunately, is that in the past these kind of conditions have been upheld, right? The circumstances were different. Okay, it could be terrorism, all right, and that time, when terrorism and all that, these conditions came into existence by law, we did not have a situation where the police would pick up a person and say, all right, I'm putting you inside for sedition, right? I'm putting you inside for terrorism, which we are facing today. Okay, you give a tweet, somebody is put inside for sedition. That never happened, in the past, that at the drop of a hat you arrest a person. But today, we are arresting a person virtually at the drop of a hat and on very, very serious charges. Sedition is a very serious charge. Okay, we are arresting persons who have given a tweet 4 years ago. Okay, that sort of a thing did not happen, that you write an article 4 years ago in 2001 and you get arrested in 2005. That sort of a thing never happened. So today the situation is somewhat different, where the police or the executive has become somewhat more powerful and has become somewhat more, arbitrary in that sense. So to put these conditions, now look at the two conditions. One condition is that you have to prove yourself to be innocent. Okay, how is the person going to do that? First of all, he doesn't know what is the case against him. Why? Because the ECIR has not been given to him. He doesn't know what the case is. So it's like shooting in the dark. You may have accused me of this offense. I have not committed that offense. You may have accused me of that another offense. I have not committed that offense. What is the person going to prove for his innocence? Secondly, the law says that he's not likely to commit that offense again. How can anybody ever come to a conclusion like that? Just think about it. Rationally, calmly, can anybody say that this person who is standing before me is not going to commit a murder? How can I ever say that? Or that this person standing in front of me is never going to be corrupt? It's impossible. It's so subjective that he's not going to commit the same offense. It's not possible to say that. So if you look at it calmly, these two conditions are very, very difficult for a person to overcome.
Quite right.
Either
Once
in
again,
past or today.
therefore,
Sorry.
once again, Justice Lokur, you have serious differences over this issue of how bail is to be obtained under PMLA with the Supreme Court. Now, the fourth issue, some people say, is the biggest concern because the court has accepted the government's position, and I'm quoting, that it cannot be said the presumption of innocence is a constitutional guarantee. In effect, that means individuals are to be deemed guilty and have to prove themselves innocent. Doesn't that position turn our jurisprudence literally on its head?
It does. It does. But again, it's happened in the past. That is the problem. So therefore, we have to look at the entire issue, in a larger context. Now, if you look at bail, for example, it's not bail is my right. It's a right of a person. It's the police or it's the prosecution that has to say why this person should not be granted bail. It's not for an accused person to say that, listen, I should be granted bail. Okay, it's for the prosecution to say this person should not be granted bail because of A, B, C, D reason. But we have forgotten that. Now we are saying that, oh, you have to apply for bail and your bail application may be rejected on ground A, B, C, D. No, that's not what is the requirement of law. The requirement of law is that the prosecution has to prove that this person must remain in custody, not for the accused to say that I should remain outside custody. So if you tie that up with the provision of innocence, right? How do I prove my innocence? You have to show that, listen, it appears from the material that I have got after due investigation and so on, that this person is a person who deserves to remain in custody. And that's the way that you can defeat his right to bail. It's not the other way around.
Absolutely. In fact, on this critical issue of presumption of innocence, what the Supreme Court did in July, just 4 days ago, actually reverses and completely contradicts the position the Supreme Court took in 2017. In 2017, Justices Rohinton Nariman and Sanjay Kishan Kaul said, and I'm quoting them, the presumption of innocence is fundamental to a person accused of any offense. Now, that position has been contradicted and, in fact, rebutted by the Supreme Court, who doesn't believe that the presumption of innocence is any longer fundamental. So the Supreme Court has actually contradicted itself and reversed an earlier position taken not so long ago in 2017.
Yeah, you're right. And you see, one of the justifications which I had adverted to earlier, one of the justifications is the perception of Parliament, right? They say if Parliament perceives a particular, situation or a particular consequence, you can't go behind it. Why? Why not? Supposing Parliament perceives wrongly, I'm taking an extreme example. Supposing Parliament perceives that jumping a red light is a very serious offense, and a person who jumps a red light should be put in jail for the next 10 years. Why? Because so many accidents happen at road crossings. So many people have died because of accidents. So very serious offense. Now, it's a fact of life that these kind of offenses, road, jumping red lights or not driving in the correct lane and so on, happen often. Can you say that, oh, because Parliament has perceived it in a particular manner, therefore I can't go behind it? Then you're rewriting the power of judicial review, and which is what has happened.
So would I be right in saying that on all the four issues we've discussed, the enforcement case report, the acceptance of a statement as evidence against the individual, the extremely onerous conditions for bail, and the presumption of innocence, all four of these, you think the Supreme Court should have struck down the amendments?
The Supreme Court should have reconsidered it and referred it to a larger bench, because some of the judgments that they have relied upon have been delivered by 5 judges. So to say that, listen, I'm going to follow that judgment because it says this, okay, I mean, you're entitled to do that. There's no difficulty on that. But is that judgment correct? If it is not correct, it needs to be reversed. Now, the Supreme Court thought that this earlier judgment of Nilesh, which you had adverted to just now, is wrong. Okay, that was delivered by 2 judges, so they overruled it because this was a bench of 3 judges. But similarly, a judgment delivered by 5 judges can also be wrong. And this is what the Supreme Court. This is why I say that the Supreme Court should have looked at it in a larger context, not nitty-gritty kind of approach.
So are you saying that in fact the issues we've discussed should have been referred to a larger bench, not struck down by the 3-judge bench, but referred to a larger bench and looked at by that larger bench in a larger context?
Yes. And perhaps the law that has been laid down in other cases with regard to bail conditions, for example, right? The Supreme Court may have said that, listen, it's wrong. You can't equate PMLA with Tata. And you can't really. You can't. The Supreme Court may have said so. How do we know? So to say that, listen, because I think, terrorism is a horrible offense, and I think PMLA is also a horrible offense. So therefore, I equate the two of them. I'm not sure whether that's the correct approach.
Absolutely. But that approach is one of the 3 justifications given by the court.
Exactly. That's what I'm saying. Yeah.
The draconian nature of the act.
Yeah, absolutely. Exactly.
The point you're making is that it is very subjective to say, I think money laundering is heinous, I think terrorism is heinous, therefore the two are as bad as each other. That is a subjective attitude.
Right. And now look at the perception of Parliament. Under PMLA, the maximum punishment is 7 years. But under terrorism offenses, Tata, it's death. Now, what do you do about that? Supposing on the basis of perception of Parliament, the Parliament decides, okay, Tata and whatever that Pota and all that, these are the same as PMLA. So in PMLA, now we're going to increase the sentence from 7 years to death. Where are we heading?
Absolutely. It's the subjectivity behind the Supreme Court's position that you have serious reservations about. Let me ask you one more question about the PMLA judgment before I talk to you about the Enforcement Directorate. The author is Justice Khanwilkar. Recently, the Oxford scholar Gautam Bhatia has analyzed several of Justice Khanwilkar's judgments, such as the Watadi judgment and such as the Tisa Setalwad judgment. His conclusion is that in all these cases, Justice Khanwilkar has converted the Supreme Court into what he calls an executive court, a court that seems to act on behalf of the executive rather than a court that embodies justice. And he says that in this instance, executive ideology has been laundered and shown to the world as sparkling, judiciously declared truth. And as a result of this, he says, the court has expanded the state's coercive powers and erased the procedural safeguards that the law otherwise extends to individuals. To what extent do you agree with Gautam Bhatia?
Well, Karan, I would not like to comment on a particular judge, right? To say that this judge is responsible for this, I don't think that's fair to the judge. So I wouldn't like to comment on it. But generally speaking, I'm not talking about Justice Khanwilkar or any particular judge. Generally speaking, I think over the last couple of years, there has been this view that the court is accepting what the executive wants it to accept, right? One of the very, very gross instances of this kind was when the government told the court during COVID times that nobody is walking on the streets, all right? And the Supreme Court took it as the gospel truth. Now, these kind of things that have been happening over the years, meaning over the last maybe 2 or 3 years, have certainly given an impression that the court is, in a sense, partial towards the government rather than towards the citizen. It could be in the matter of listing cases. It could be in the matter of, granting adjournments. It could be in the matter of decision making. That perception has gathered over the last couple of years.
Let's at this point come briefly to the Enforcement Directorate. The Minister of State for Finance, Pankaj Chaudhary, has told the Lok Sabha that 5,422 money laundering cases have been registered, but only 23 people have been convicted. That comes to a conviction rate of less than 0.5%. Doesn't that one fact alone raise serious questions about the quality of cases that have been registered?
It raises two questions. One is about the quality of cases. Number two, it raises questions about the investigation. You can't investigate a case properly, so therefore you bring in draconian laws, right? You say that whatever you say will be used against you. All right? Now, that's how investigation suffers. And the Supreme Court has said on several occasions, not only in PMLA, but in IPC offenses, that the investigation is shoddy. So, instead of trying to improve the investigating process, trying to get better material, trying to have more intensive and extensive investigations, the laws are being made more draconian. That is what is vitiating everything. So you say, oh, I'm not going to give you bail. You're not, because the law says so. Then bail becomes punitive. So then it doesn't matter if this person gets acquitted after 5 years, because he spent 5 years in jail. Maximum period is 7 years. He's already spent 5 years. So what? I've achieved my purpose. So you have to look at this mix, of poor investigation being substituted by draconian laws. That's where the problem lies.
Now, secondly, the Lok Sabha has also been told that 65% of all money laundering cases were filed in the last 8 years, which means they were filed under the Modi government. Given the extremely low conviction rate, is this sharp increase in the number of cases filed in the last 8 years another cause of concern? Does it not raise the question, why are these cases being filed?
Yeah, you're right. You're right. But these cases are being filed because you want to punish somebody by putting him through a particular process, which, as the Supreme Court has said, is a punishment by itself. So you first put him into a particular process, and then you put him inside jail so that he can't come out. Why? Because you know that person is guilty. So whether you have a conviction against that person or you have an acquittal against that person becomes irrelevant. Okay, so you believe that person A is guilty. I'm going to put you through a torturous process. I'm going to put you inside, make it a punishment, and we'll see after that, after 5 years, what happens.
Except that belief could be wrong because no guilt has been established. So you are agreeing that the problem with PMLA is that the process becomes the punishment, regardless of whether guilt is established or not.
Yes, process becomes the punishment. Number one, the incarceration also becomes punitive. In the recent past, incarceration has become punitive. Where you pick up a person for a tweet and you say, I'm putting you inside for sedition. Does that make any sense if it's not punitive?
This is why you believe that the whole PMLA Act should be seen in a larger context and referred to a larger bench and thought about very carefully, because your concerns about it are serious concerns at multiple different levels. This is why a larger bench, perhaps a 7-judge bench, needs to examine this very carefully and consider its constitutionality and legality very carefully.
Yeah. Well, at least a 5-judge bench, if not 7 judges, 5 judges. and then maybe 7 judges on some aspects. Yeah, why not?
Finally, what do you make of the fact that increasingly the PMLA Act seems to be used against political opponents of the government? We have endless examples of that coming up in the news practically every month.
Yeah, yeah. Yeah, well, it's used as a tool against anybody whom, you don't like. If that person happens to be a political opponent, well, his bad luck, what can be done about it? That's why, sorry, Karan, that's why the need to have a look at it in a larger context.
Absolutely, because it is a tool in the hands of a government who can use it vindictively against people they don't like, regardless of whether guilt is established or not. For that reason, it needs to be looked at very, very carefully.
Right, absolutely correct. Yeah.
So then, my last question, are you disappointed with the more or less, I'm using that word deliberately, cavalier way in which the last Supreme Court bench looked at this and treated it?
No, I would not use the word cavalier, but yes, I am disappointed. But not because it's cavalier, but because it deserves far more serious, consideration.
Okay, not cavalier, but you're disappointed because the Supreme Court should have given this issue far more serious consideration.
Yes.
Justice Lokur, thank you very much indeed. Take care.
Yeah, thank you.
Stay safe.
Yeah. Thank you.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Thank you for your time. Goodbye.